and our two speakers joining me today are Malcolm Holmes QC and Jim Morrison, who are together the co-chairs of the ACICA Rules Committee. We're now recording, so let's get started. Thank you so much for joining us today as we go through the ACICA rules. We're in the process of revising them, as you are well aware, and that's why you've joined us. So thank you so much for joining us. Today is really going to be a quick snapshot of the proposed changes to the 2016 rules. That's because we only have an hour and there's quite a bit in there. Jim and Malcolm will take you through these changes, quick snapshot, and probably point you to what we'd really be grateful for all of you to help consult on, you as the users. These are rules that, well, you'll hear more about them in a second. Just a few things. So again, grateful if you can turn off your videos and turn off mute. If you have a question, some of you should have a little icon of a hand raise. Alternatively, you can write down your questions in the conversation, which is to the right of the screen, or email them if worst case. But we probably won't have time for Q&A during this session because we have quite a bit to go through. I haven't introduced our speakers. As I said, Malcolm Holmes QC has decades of experience in international arbitration and otherwise. He's also written extensively on these issues, and he's been involved in the Rules Committee for quite some time now. Jim Morrison is a partner at Peter & Kim. He previously worked at law firms in Korea and also in Australia, and also was previously at the ICC. So I'll open it up now to Malcolm Holmes to commence and give us just a little bit of a background on the ACICA rules generally and what the ACICA rules are based on. Thanks, Malcolm.
Thank you, Carolyn. Well, welcome all. I'm here to basically give you a few snapshots of the proposed changes, but we're very much at the consultation stage and discussion about which option should be adopted. And so we're hoping that this will stimulate interest and further suggestions. But I think it's necessary to start with a consideration of how we've got here. ACICA was formed in as far back as 1985, before we adopted the model law, and we didn't have a set of rules until 2000. But in the meantime, ACICA had acted as an appointing body under rules such as the UNCITRAL rules, a bit like the Sino-Dragon case where ACICA was recently suggested as the appointing authority, but the parties couldn't agree and it went to the Secretary General of the PCA. After those rules were adopted, and the approach there was very much a light touch, so that the involvement of ACICA didn't require much institution or administration experience, but there has been a gradual accretion of experience and supervision of arbitrations. The next step was in 2007 when mediation rules were adopted. Then in 2007, a specialist set of rules were adopted for the AMTAC, the Australian Maritime and Transport Arbitration Commission. And then there was a revision in 2011 incorporating emergency arbitrator provisions. We were one of the first institutions in the world to provide that service, which filled in the gap between the time of the dispute and the formation of the tribunal. At the same time, ACICA adopted expedited arbitration rules. Then we had a further edition of the rules in 2016, and now we've come to the stage of looking at, there have been some changes in the last 4 years. What changes should we introduce? And hence we've got this current exposure draft. So the ethos is continuing with the light touch, but gradually reflecting the store of knowledge that we've gained by administering arbitrations since 2006. And with that, I'll hand over now to Jim, who'll deal with the exclusive administration.
Thanks both to Carolyn and to Malcolm. I have to say it's very exciting actually to be participating in this consultative launch today. This basically is the culmination of at least some 18 months of very hard work by our committee to put together this consultation draft, including during the unfortunate COVID period. So it's great to see so many friendly faces in the lobby room. There are a lot of friends of ACICA here today. So we're really counting on you to let us know where we can take this draft and what we can do with it to provide the best arbitration service possible. Due to the hard work of previous rules committees, we actually didn't have our work cut out for us in this process. Because we already have such a tried and tested product, what we were able to do actually as a committee is really take a step back and then a deep dive into various areas. We focused on three related ideas. Where can efficiency be gained? For instance, time limits for awards, that's one thing we'll talk about. Where can the institution add value? For instance, is there a greater role that the institution can be playing in the constitution of the tribunal? And lastly, where could we possibly innovate? And alternative dispute resolution and ArbMed is one area which we'll talk about. The approach that we took as a committee is actually quite similar to previous rules revisions, but there have been some changes. Like ACICA's caseload, our rules committee in 2020, with some 13 members, is bigger than it was in 2016, where there were only 5. The committee is also much more diverse now in terms of gender, professional affiliation, and geographical location, both in Australia and overseas. We consist of leading arbitrators, counsel, both from the bar and from the law firms, academics, and also in-house counsel. We've all got strong experience working with ACICA, but also other rules. And gratefully, we've been ably supported by the ACICA Secretariat in this process, explaining to us in real time what is working really well and where can we be doing things better. So because we've been a bigger number in this committee this time round, we've actually been able to break up into smaller teams and take these deep dives into these areas together, come back to the larger committee with some proposed ideas and drafting. We've been able to socialise those ideas and put together this draft, which you have today. I think it's been a good process. It's allowed us to comprehensively take a look at the rules, and we're really excited and interested to hear what you have to say about them.
Thanks, Jim. If I can now just highlight a couple of the changes. Under the changes to the exclusive administration, if you look at Articles 1.2 and 2.1, there's a provision which endeavours to preserve the intellectual property and the administration of the ACICA rules by ACICA, and to stop other institutions or parties adopting the rules without the involvement of ACICA. It's an unusual feature of international arbitration that parties want the benefit of the rules, but sometimes don't want the institutions to take part in the proceedings. And they don't want to pay the registration fees for the supervision and oversight by the institutions. Now, one of the early arbitrations I was involved in was where a very experienced arbitrator had 2 parties who wanted to use a particular institution's rules, and they approached this arbitrator and said, can we do that? And the experienced arbitrators counselled them against it, but nonetheless they wanted to. And he sat down and rewrote the arbitration institution's rules without reference to the arbitration institution. And the parties then adopted a fresh arbitration agreement, which was essentially an ad hoc arbitration agreement, which they had written. He was then, there was a challenge to his impartiality and independence, and so I came along as the replacement arbitrator. But it's also been the subject of a number of cases, especially in Singapore, where there have been attempts by parties there to use institutional rules without the arbitration. Oh dear. Sorry, can you hear me?
We can.
Hello.
Maybe while Malcolm is dealing with his technical difficulties, maybe Jim, you could speak about written communications.
Sorry. All right, I've just come back.
Oh.
Do you want to finish off what you were saying, Malcolm?
All I was going to finish is this is more an aspirational rule to try and protect the integrity and the usage of the rules and the reputation of ACICA. And it's a reflection that we are an institution which people wish to copy, and they wish to use our rules. So I regard this as another tick as the institution is becoming more established. And
Thanks, Malcolm. I'm just going to speak briefly about what seems to be a small change, but actually from my experience, having worked in administering arbitrations, it's an important one. It's Article 5, and it's a new rule by which the ACICA Secretariat is to be copied in on communications between the tribunal and the parties' representatives. One of the greatest value adds in an ACICA arbitration, but which you don't actually expressly see in the rules, is the Secretariat. In Australia, it's a small, but it's a highly experienced and efficient team. And it's the invisible hand that is responsible for applying the light touch that Malcolm referenced earlier. Currently, ACICA encourages tribunals and parties to copy the Secretariat on correspondence, but unfortunately, that doesn't happen in every case. And so we wanted to give some more force to that requirement, because we see it's losing one of the benefits that the institution can add to the process. It enables the Secretariat to track the case, support arbitrators and parties where they need, and it helps to move the case along so that cases just don't disappear into the abyss. So we can keep pushing the case forward to conclusion, and also ensuring due process along the way. And this new requirement is going to prove particularly important moving forward if some of these other changes that Malcolm and I are going to discuss today are adopted, because they're really going to require the institution to be more active in monitoring the case. And so that's maybe something that we can move on to Carolyn.
Yeah, and I think you're covering our next topic as well, which is confirmation of arbitrator, where this is really going to come into, well, this will be starting the process. If you could just give us a few comments about that, Jim.
Sure. It's quite an interesting change from an ACICA perspective, because it's starting to bring a heavier touch to ACICA's involvement in the constitution of the tribunal and policing independence and impartiality. Currently, ACICA only appoints arbitrators where the parties fail to do so themselves. And actually, that doesn't occur very often in ACICA cases. Parties are very responsive in taking up their rights to appoint an arbitrator. So at the moment, the institution effectively is just acting more as a mailbox for independence forms from arbitrators. the Secretariat checks that they've been completed properly and then communicates them to the parties. So at the moment, if there are issues of independence, and they rarely occur in ACICA cases, as I said, they're dealt with at the stage of a formal challenge to the arbitrator after she or he has already been appointed. There's no opportunity to ventilate these issues of independence before the mandate is already in place. So under this new confirmation procedure, the mandate and independence of all arbitrators nominated by parties or other arbitrators will be considered by ACICA, and then it will be given effect through an administrative decision. The committee considered that greater institutional engagement by ACICA through this process will have several benefits. Sorry about that, and now I think I'm back. So the first benefit is obviously the opportunity to be heard, the ability to comment on an arbitrator disclosure before ACICA decides to confirm that arbitrator. This is going to help cases start off on the right foot, airing these issues, clearing them up at the outset, and avoiding a post-appointment challenge. We think this is going to help increase confidence in our tribunals. The next thing is that we think this process is going to enhance what is already a very good practice in ACICA arbitrations in terms of full and robust disclosure by arbitrators. Knowing that their forms are going to be formally reviewed by the institution as part of its decision-making process, we hope that this is going to encourage arbitrators to take more time and consideration in carefully making their disclosures. Also, we think that the new confirmation process is going to assist in standardizing the Constitution process and the timing by which arbitrators take up their mandate, because it's going to become effective upon the administrative decision of ACICA. And where there are going to be 3 arbitrators, it's going to assist in enabling the co-arbitrators to be confirmed together rather than at different times because of the different appointment times currently under the rules. This we think is going to enhance equal treatment between the co-arbitrators. The other thing we think getting ACICA to play a more active role in the confirmation process will achieve is that it's going to give the institution a more dynamic understanding of these issues of independence and impartiality than it currently does. ACICA is going to be able to be better across the trends and the issues, and it's going to be able to contribute more to education and research to improve practice and procedure. Obviously, there's work to do in considering this rule proposal yet. In particular, one area of discussion which was quite animated, I'll say, during the deliberations of the committee, is the scope of the power not to confirm an arbitrator, particularly where there's been no question or objection raised by any of the parties to that nomination. You know, is there some information that the institution has, for example, that might cause pause in confirming that arbitrator, notwithstanding there's been no disclosure and no objection? Another concern that the committee had was, well, if it's a completely clean confirmation, if I can call it that, where there is no disclosure and there is no objection, why should the appointment process be held up by waiting for the ACICA decision-making body to convene a meeting to confirm that appointment? So another thing we're proposing is that in appropriate cases where there's a clean confirmation, the Secretary General can be delegated that confirmation power, but always ensuring that the confirmation decision and the arbitrator's forms are communicated to ACICA, so that that oversight process is still maintained. So that's a very brief snapshot of what is actually quite an important change in the time available. But as I said, this is one area where we're really depending on you to help us navigate this change, and we'll appreciate your feedback.
Thank you, Jim. That's really helpful. And speaking from the Secretariat point of view, it's something that we deal with quite frequently. Well, not quite frequently, but we certainly have dealt with in my tenure. And it's quite difficult when, particularly in cases where parties have agreed to nominate an arbitrator, but haven't actually had the chance or opportunity, or don't realize that they are able to do the legwork to ensure that the arbitrator not just is impartial, but also has the appearance of impartiality. So it's a very important change, at least from our perspective. Now moving along in the proceedings, so to speak, now that we've appointed our arbitrator, potentially appointed our arbitrator, why don't we speak about complex arbitrations? Malcolm, if you could talk to us about the consolidation rules and how those may be changing. And join
All right, thank you, Carol. Under the present rules, consolidation may be ordered by ACICA in three circumstances. One, where all the parties have agreed to the consolidation. So that's fairly simple. You've got essentially a fresh arbitration agreement by all the parties who are affected by the consolidation. The second one, in Article 14, is all claims are made under the same arbitration agreement. So all the parties are bound by the same arbitration agreement. Now, the significant change is to paragraph C of Article 14.1. There, the claims are made under more than one arbitration agreement, but then these words, the arbitrations are between the same parties. Now, that restricts the power of consolidation to a very limited number of classes of arbitrations. What's proposed is that the words, the arbitrations are between the same parties, are deleted. So then you can address a chain of contract situation. You can address multiple parties with multiple contracts. Now, that's a fairly expansive power, which we're discussing whether it should be granted to ACICA. But these days, more and more comparison is made between the arbitration process and the judicial process. And so in the same way that the emergency arbitrator filled that gap between the time of the dispute and the formation of the panel, which courts have always had that facility, courts have a power to join, consolidate proceedings, and the arbitration community has looked at that to try and provide the same facility to parties to several arbitration agreements. So that's the consideration of the board at the moment. Should they empower ACICA or get the parties to empower ACICA by making those changes to the rules? Now, there's still the following requirements in paragraph C, namely that although there's multiple parties and multiple contracts, there has to be a common question of law or fact, or the rights to relief arise out of the same transaction or series of transactions, and ACICA finds the arbitration agreements to be compatible. The other change is the shopping list of matters that ACICA has to take into account when making that decision to order consolidation. On one view, it can be set out in the new Article 16. On another view, why hamstring it? Why don't we put it in a practice note? That enables the institution to update it and to revise it, but all the while not going beyond paragraph C, the common question of law and fact, the relief claimed are in respect of the same transaction, and the arbitration agreement is compatible. So that's the significant change that the board is considering. The other change is that due process is a matter which is at the forefront of most arbitration practitioners, and the paragraph, it's proposed to put before the words ACICA in the first line, upon request by a party, and then you insert the words, and after consulting with the parties and the arbitrators, ACICA may consolidate. So there's a requirement to address due process that ACICA asks for the views of all the parties who are affected by the proposal to consolidate the two disparate arbitrations. If I can turn then to joinder, this was the old provision, Article 15, and upon request by a party or a third party, the arbitral tribunal shall have power to allow a party to be joined if the additional party is bound by the same arbitration agreement. Now the power is is given to ACICA, and it is after they have consulted with all parties affected by the proposed joinder. So that's just a due process update and revision. And there, in a nutshell, are the changes to consolidation and joinder. Thank you, Carol.
Thank you, Malcolm. And that's, again, consolidation and from time to time joinder are issues that we see at the Secretariat quite often. So we're grateful for the Rules Committee for looking into this issue. Another issue that we see quite frequently at the Secretariat are multi-party contracts. Jim, if you could talk us through the proposed changes to that, that would be really helpful.
No worries. And this issue rides comfortably off the back of Malcolm's helpful exposition on the consolidation provisions. Currently, there's no express provision in the ACICA rules which addresses the multi-contract dispute situation. That said, there has always been a good number of multi-contract cases before ACICA. Large infrastructure disputes are no stranger to the ACICA rules. That said, the rules have proved flexible enough in the past and currently to accommodate the multi-contract complexities in any event. That said, based on this experience and also often some of the inquiries the Secretariat receives from parties, the committee considered that it would be helpful that we do have an express rule which deals with multi-contract disputes that would enhance certainty around the process for commencing a case where multiple contracts are involved. Obviously, such a tool will also be useful in terms of efficient case management. Having one arbitration as compared to many will reduce arbitration fees and costs. And it's also going to minimise some of the procedural complexities we see in having to coordinate multiple related parallel cases. Now, the purpose of the new Article 18, which deals with multi-contract disputes, is to allow a claimant with claims under multiple contracts, either between the same parties or depending on which way your feedback goes and the board decides, or different parties in chain of contract situations, to commence a single arbitration in respect of all of those different claims. And as I said, this procedure will complement and work in tandem with Article 16 on consolidation that Malcolm just described. So this new Article 18, it shares some close cousins in some of the provisions in the updated rules that you'd all be also familiar with, such as the ICC rules, the CIAC rules in Hong Kong. but they all vary in their scope and application. The way we've approached this issue is that Article 18 will operate by first deeming that notwithstanding a single notice of arbitration has been filed in respect of the multiple claims, the claimant has nonetheless commenced multiple arbitrations until such time as ACICA decides to accept that deemed application for consolidation. So it requires the claimant in the multi-contract notice of arbitration to apply for ACICA consolidation. ACICA will then provide an opportunity for the other parties to comment on that application and then make a decision. And in doing so, ACICA will apply the same criteria that Malcolm just described in terms of Article 16. So there will be a unified approach to consolidation in both the multi-contract and multi-arbitration contexts. And consistently with ACICA's pro-party autonomy kind of philosophy, no matter what Article 16 and 18 say, as Malcolm mentioned, if the parties agree to consolidate, then ACICA will give effect to the parties' agreement and support that. So that's always important to remember.
Thanks, Jim. Malcolm, do we still have you?
Yes, you still have me.
Okay.
And I see we're being rejoined by Ian. Now, the next matter which we've introduced a slight change is how do you address the possibility that other dispute-solving techniques may be more appropriate? The contract may be a large infrastructure project where the transaction lawyers thought the matter should be arbitrated. But then when the dispute arises and the parties attend for the preliminary meeting, they think, can we avoid arbitration, or should we think about arbitrating some of the disputes and mediating others? And so the rules have gone through a stage of development where in the last edition of the rules, we introduced provisions for the preliminary meeting. In the early stages of arbitration rules, they were opaque about whether or not there should be a preliminary meeting or a case management conference, or whether or not there should be a set of terms of reference adopted. So what we've had in the existing set of rules, in Article 21.3, as soon as practicable after being appointed, the arbitral tribunal shall hold a preliminary meeting of the parties and make a procedural timetable. So this was holding the hand of a new arbitrator and telling the arbitrator how the proceedings commenced in terms of getting the parties together. Then the question was, should they consider mediation or other forms of dispute resolution? Now, parties at the time of the previous rules were concerned about if one party suggested, why don't we mediate, that may be mistaken as a sign of weakness or lack of belief in their case. And so the Rules Committee thought the approach should be that the arbitral tribunal should raise for discussion the possibility of using other forms of dispute resolution. The feeling was it shouldn't just be in favour of mediation. There may be other forms such as expert determination or executive appraisal or early neutral appraisal. Now, what has happened with the new set of rules, the same provision is there in Article 24.3. The last sentence reads, the arbitral tribunal shall raise for discussion with the parties the possibility of using other techniques to facilitate the settlement of the dispute. But then there's a new 24.4, which recognises the general acceptance of a mediation and arbitration process being combined, and that provision reads, on the application of any of the parties, the arbitral tribunal may suspend the arbitration to allow for a mediation or an other form of dispute resolution on such terms as the tribunal considers appropriate. So the parties can go off and use other forms of dispute resolution, but a party can't be dragged off against their will, because the concluding sentence of 24.4 allows a party to require the arbitration to resume at any time and without any particular reason other than the party wants the arbitration to resume, and they just make a written request, and the parties and the tribunal are obliged to resume the arbitration process. So that's the question of preliminary meetings. We haven't gone with adopting any form of terms of reference. That's peculiarly an ICC provision. They've had a lot of success with it. There was in the ACICA Rules back in, I think, 2007, they tried to emulate that and incorporate it, but that didn't last very long, and it was removed in the following version of the rules. We've kept it quite brief and only required the procedural timetable and raising this matter for discussion. So that's the change.
Thanks, Malcolm. Jim, if you could just take us very quickly through the preliminary disposition of issues addition or proposal, that would be wonderful.
Of course. So very quickly, the current ACICA rules do not contain an express provision empowering the tribunal to make an award on preliminary disposition of issues. The committee is proposing that we introduce an explicit provision in this regard in new Article 24.7. Now, the change was seen as being helpful in terms of drawing the eyes of the parties and the tribunal to what can be a useful case management tool to assist in narrowing early on in the case the issues and thereby expediting the arbitration overall. The committee didn't see it as a controversial change because new Article 24.7 just recognises a power that is largely considered to be inherent in most arbitral rules anyway. For instance, that's the position that the ICC takes. Although there's no express provision in the ICC rules directed towards preliminary disposition of issues, you'll see in the ICC practice notes that that is a practice that is encouraged by that institution to assist tribunals in managing time and costs. The approach that we've advocated in the rules revision is a very general approach. It's less prescriptive in terms of the basis and grounds upon which the power can be invoked by the tribunal compared to some other institutions. So it's going to be a general power which is to be exercised by the tribunal in its discretion in light of all the facts and circumstances of the case, depending on the arbitration. So that's the quick version, Carolyn. Thank you.
And Malcolm, one more quickie before we get into some more of the bulkier topics. What's the deal about time limits for awards?
Well, under Article 35 of the present rules, there's a requirement for the tribunal after the parties have had their evidentiary hearing and have put in their submissions either at the hearing or post-hearing submissions to declare the proceedings closed. Now, what's proposed is that from that date, the tribunal has 3 months to deliver the award. That's one option. The other option is from the time the file is transmitted from ACICA to the arbitral tribunal, then the award shall be made no later than 9 months after that date, or no later than 3 months after the proceedings were closed, whichever is the earlier. This is an endeavour to ensure that the proceedings are prompt, efficient, and the hearing and the time taken for the arbitration is within the 9-month period. It's that 9-month period, whether it be 9 months, 10 months, 12 months, that's a matter where minds may differ. And if anybody has a particular view, I'm sure the board would like to hear from you about that. The ICC has a provision, a similar provision, but in the ICC rules, as we're suggesting in Article 38.3, ACICA has the power to extend that 9 months upon a reasoned request from the arbitral tribunal, or if ACICA otherwise deems it necessary, so that it ensures the ACICA has an oversight about the speed that the arbitration is taking to completion, and that the arbitrators are not off on their own handing down awards years later, or it's a provision which allows ACICA to ensure that there is no unnecessary delay.
Thanks, Malcolm.
Thank you.
And that's, of course, a topic that is important both to arbitrators but also to parties, because no one wants young junior lawyers to have heart attacks because they're working around the clock to try to rush through submissions. But equally, parties don't want to have to wait too long to receive their award. So it's a very delicate balance, time limits. Now moving on to everyone's favorite or least favorite topic, which we've called the financials. Jim, if you could talk us through the cost of arbitration proposed changes, that would be great.
Well, I guess Malcolm's just addressed the stick in terms of the time limit for the award. I guess I'm going to address the carrot in terms of the money for rendering the award. The way that ACICA manages and oversees arbitrator fees is one area that the committee proposes making some interesting changes to the ACICA rules. Currently, ACICA plays a minimal substantive role, but a large administrative role when it comes to fixing the fees of arbitrators. At the moment, developing a budget for the arbitrator's fees is largely left to the arbitrator. They agree on an hourly rate with the parties, and then they estimate their own deposits. Then, after that money is taken on board, before rendering an award, they give the ACICA Secretariat an accounting of the time spent and direct their fees based on that hourly rate to be paid from the deposits. ACICA's role in that process currently is limited more or less to receiving, holding, and paying out arbitrators' fees on their instruction. ACICA also has the power to fix an hourly rate for the arbitrators where they fail to agree on that rate with the parties. Rarely has that ever happened in ACICA practice over the entire history of ACICA, interestingly. So with that short introduction, what are we proposing to change? Organisationally, the cost provisions are going to be consolidated into one section of the new rules. Because at the moment, because of different reasons, historically, they tend to be a bit scattered through different sections. So organisationally, one place you need to look. Substantively, there are going to be changes proposed in terms of the way that arbitrator fees are calculated, estimated, and deposited at the outset of the case, and then paid out to arbitrators at the end of the case. Under what we're proposing, While the hourly rate will still be the barometer, the well-tested barometer in our experience by which arbitrator deposits are calculated, the Secretariat is going to be working more closely with arbitrators and parties to develop a budget at the outset of the case. Based on those discussions, ACICA will be then invited to consider the proposed budget and then again administratively decide to fix deposits that are to be paid in by the parties for arbitrator fees. ACICA will still retain this rarely used power to step in and fix an hourly rate as well if the parties can't agree with an arbitrator. So once the money's taken in on that basis and the case runs in accordance with the new time limit for the award, at the end of the case, ACICA will administratively decide and fix the arbitrator's fees that are to be paid. In that process, it's proposed that ACICA will have the discretion to reduce arbitrator fees to take into account efficiency and other considerations, including by reference to the new proposed time limit for the award. So importantly, one of the ideas in terms of value add for by the institution in this process is that ACICA is going to be in more regular contact with arbitrators throughout the life of the case to monitor that the work that is being done and that remains to be done is commensurate with what funds are on hand and what remains to be done until the end of the case. We're hoping that will provide parties with more certainty around the fees that they will expect to be paid, expect to have to pay. It will also reduce, we think, the upfront burden, especially in large complex cases where a lot of money may need to be paid up front to secure the work of the tribunal moving forward. This monitoring role will also help avoid surprises at the end of the case and 11th hour requests for top-up fees by arbitrators. Again, fortunately for us, ACICA arbitrators have proven to be extremely efficient and reliable in terms of estimating their fees. However, what we want to get your feedback on is having the institution more involved in working with parties and arbitrators to establish budgets which are manageable and commensurate with the parties' expectations for that case, and put some more transparency around that process. The last thing that I'd mention is that in terms of ACICA's administrative fee, there will be no change substantively. That will remain to be determined on the basis of the amount in dispute and the sliding scale. And we're hoping that that ACICA can continue to be competitive in this regard compared to and relative to other institutions. So that's the short of it, Carolyn.
Thanks, Jim. That was a pretty good snapshot of a very complicated topic. Now, Malcolm, we have two more topics to cover with you. I note that we have 10 minutes before my husband's time of the hour of being outside in Melbourne runs out. So why don't we quickly turn to the first one, which is third-party funding, before my dog returns and starts barking.
All right, I'll be very brief on this one. Third-party funding wasn't a feature of international arbitration with the last version of the rules, and so there's no provision there whatsoever. Third-party funding, I see, is mainly in litigation involved in the class actions context. And class actions context and third-party funding is something that I see in the recent days. Even the government is talking about being involved in resetting the parameters of it in litigation. There have been a lot of discussions, a lot of reports on third-party funding, but ACICA has gone softly, appropriately in my view, just to deal with two matters, and that is we accept that it's a feature of international arbitration, but it should be disclosed at the outset. so parties know that there may be other people who are aware of the litigation and there may be possible conflicts. So there's an obligation in the new Article 53 to disclose the existence of a third-party funding agreement. Then there's an obligation to ensure the confidentiality of the proceedings where you involve a third-party funder who becomes privy to certain matters. So they're the two features that the rules address. And again, it's just a light hands-on. So I don't think we need to deal with third-party funding, Carolyn. I think I'll move on now to ARB-MED or MED-ARB.
Our most controversial topic.
Yeah.
The best one for last, some could say.
All right. And I'll be very brief on this. We recognise that mediation is possible, and at various stages during the proceedings, there should be a power for the tribunal to suspend the arbitration to allow the parties to mediate or engage in another form of alternate dispute resolution. So that is added, and we put in there an obligation to do that in accordance with the ACICA ARB-MED or MED-ARB protocol from time to time. Now, the contentious matter is, should there be mediation by the arbitrator? So there's two views here. One is no, and the other is, well, yes, if you follow the protocols of the provisions of Section 27D of the Commercial Arbitration Act, there are some safeguards that if an arbitrator takes off his or her arbitrator's hat and puts on a mediator hat, then before resuming, you have to get the parties' consent before you resume as an arbitrator. And there was that recent case of Ku-ring-gai Council where those involved forgot to get that, and the arbitration award was set aside. There's a similar sort of protocol that you need their consent of the parties before you resume arbitration, or you don't need their consent if you have not obtained any confidential information. So, for example, if there wasn't private caucusing with individual parties, but there was just a round table discussion of all the parties, then you wouldn't need consent because both parties heard what you were told. There was no obtaining of information in a confidential setting. All right, so that matter is still under consideration, whether or not there should be a recognition of an arbitrator acting as the mediator of the same dispute. And Carolyn, that's all I think I've got time for or needs to be said.
Well, you actually had another minute or two, but I think that's one of those topics that, again, we'd welcome everyone's views on. And I should say that there is a mechanism for you to give your feedback. There is a survey that we have created, and it goes through each of these proposals. It will be sent to all the participants or people who have registered for this discussion. It will also be available on the website if it's not already. Deborah's quite efficient, so I wouldn't be surprised if it's not already up there. And it will also be sent out to all of our corporate members. That survey will allow you to have listened to this lively discussion. All of the burning questions or comments that you've had this entire time can then be inserted into that survey. So your voice will be heard, and we encourage you to have your voice heard, because this whole process, this consultation process, is about you having a say in the rules that ACICA is ministering. And I can't promise that everything that you say will be included, but it will certainly be considered. And I shouldn't even say that I can promise that, but I assume that Jim and Malcolm will promise that on your behalf. I'm just a mere conduit, a mere pawn in this. But I first want to thank all of you for joining us today. I should also say, Jim or Malcolm, do you have anything else that you'd like to add for anything that we've discussed today?
No, I just want to thank ACICA for setting up the survey. I think that's very useful, and people who have attended this obviously have an interest in the subject matter, and we'd love to hear your views. Thank you.
Jim?
And I also just have a thank you, and that's to the other members of the committee who just did an excellent job. You know, there were weekend workshops. The amount of time that has gone into producing this consultation draft has been considerable by all involved, and really just like to thank colleagues and friends on the committee for pitching in and producing what I think is you know, a really encouraging step for arbitration in Australia.
Thanks to you both, and thank you so much for your time in explaining this to everyone, and thank you so much to everyone who joined us. I think that, yeah, questions, comments, please provide your feedback in the survey. We really hope that you will participate. I think that's all that I needed to say. I think I need to let my husband back in before he gets fined by the cops. For all of my fellow Victorians, be safe. Please take care of yourselves. And for those around the country and around the world, same goes for you. Hopefully you're not subjected to curfews. But you'll at least stay safe, and we hope that you're all well. Thank you so much for joining us today.
Thank you. Thank you.